Is this any of this getting into your guys' little skulls? Or
They're back.
You can't possibly feel like you're doing the right thing. There's no fucking way you can feel like you're doing the right thing. Definitions for racketeering activity unlawful. Documentary material means any book, paper, document, writing, drawing, graph, chart, photograph, phonographic record, magnetic tape, computer printout, other data compilation. That's a data compilation right there, you guys.
Yeah, keep hiding your face.
Documentary material. Data compilation. From which information can be obtained or from which information can be translated into usable form or other tangible item. Enterprise includes any individuals, sole proprietorship, partnership, corporation, business trust, or other profit or non-profit legal entity, and includes any union, police unions, association, or group of individuals associated in fact. You're all associated in fact, just standing there together. Although not a legal entity, and both illicit and licit enterprises, such as a police department. Racketeering activity includes conduct of a person committed both before and after the person attains the age of 18 years and needs to attempt to commit, to conspire to commit, or to solicit, get this, to solicit, coerce, you hear that, coerce, or intimidate another person to commit any conduct that constitutes a crime as defined in ORS 161.515, crime described, which means a misdemeanor or a felony. Under any of the following provisions of the Oregon Revised Statutes. There's a lot of them here.
oh yes.
You can ask, of course.
There's a lot of them here.
You're not going to.
No.
Bribe giving, bribe receiving, perjury. You guys all perjured your oaths with your actions. Did you know that?
Do you know what?
Or your inactions.
Put a mask on it
Your
and then
omissions.
go in.
Omissions of
Absolutely
action.
no problem.
It was
Why are
covered
you
in
trying to force
coercion.
a mask on me?
No, Section 1H.
Do you know that trying to force a mask on me is the same as forcing me into involuntary servitude? That's ORS
Unsworn
163.263. Right here, I have the whole thing.
Obstructing governmental
wanna
or
read it?
judicial administration.
Take it off the belt, please. Remove it from the belt. Remove all this from the belt.
I just want you to read this.
I don't have time to read. Remove.
Obviously. I'll read it to you, okay? I'll tell you what involuntary servitude is since you don't know what it is. A person commits the crime of subjecting another person to involuntary servitude in the second degree if the person knowingly and without lawful authority forces or attempts to force the other person to engage in services
Or anything like that?
No.
by
Maybe on my jacket.
abusing or threatening to abuse the law or the legal process.
And if
but to delete the no contact provision between two co-defendants alleged to have committed a person felony it doesn't seem to be an appropriate action given the allegations. Mr. Collins is alleged to, some of the background is that there's a YouTube channel, there are concerted efforts to go and test mask mandates, and I understand that part of that, and to prevent this from further happening, to protect the public from further assault of these two individuals.
So first of all, let me just say that I disagree with Mr. Brinson's contention that orders violate anybody's First Amendment rights or Sixth Amendment rights with regard to the not having a purpose. They do have a purpose. The purpose is to protect the public from the incident that I'm aware of. You see the affidavit, it appeared that these folks went into the store live streaming it as part of apparently a channel or some kind they have where they go around challenging different businesses to engage in some sort of challenge about the mask mandate. That leads to circumstances that spiral out of control. They're purposely agent provocateurs in essence going around trying to get a result and threatening to sue people for the result of that result. So I think there's a public purpose for not allowing them to continue to be together. So it sounds like the only matter that I have that's in any way contested is the purposely agent provocateur Colin matter. That's the motion to change venue. So we'll take that up. All right, let's start with, let's take up then the matter of State of Oregon versus Ricky Scott Collin, 21 CR. Purposely agent provocateur. (53965). This is here on a motion to change venue. Ms. Counter.
Good morning, Your Honor. Thank you. Amy Counter appearing on behalf of Ricky Collin, who I signed in virtually. I would rely on the defense's motion papers. Some of the authorities cited therein include Article 1, Section 11 of the Oregon Constitution and the Sixth Amendment of the United States Constitution, which provide that the accused shall enjoy the right to a speedy and public trial by an impartial jury. Furthermore, the state of Oregon has codified a procedure for securing this right.
Ms. Counter, hang on. I'm going to stop you for 1 second. Mr. Miranda, maybe you need to turn your mic off because I'm getting a lot of feedback here from somebody. So, Ms. Counter, is that okay now?
I believe so, Your Honor. It sounds better.
All right. So then the other thing, before you make your argument, I'm not sure what you're referring to because all I received was the blanket motion, a blank motion, 1-page motion saying we move for this. There's nothing else attached to it. So when you referenced your memorandum and declarations and stuff, I don't have that. I haven't seen it. If you filed it, it hasn't made it to my file. So I just want you to be aware of that. And my staff just handed me a note. Apparently there was an indictment issued. Can we just get him arraigned on the indictment at this point in time real quickly so he doesn't have to come in for a separate date just to deal with that?
Yes, Your Honor. We are scheduled for a 35-day call this afternoon. I did receive a copy of the indictment. I did forward a copy of the indictment to Mr. Collin via email. If Your Honor would like to proceed with an indictment on that or an arraignment.
Sure. So is he named correctly in that?
Yes, Your Honor.
And date of birth is correct?
Yes, Your Honor.
And that is his true name?
That is his true name, Your Honor. Yes.
And do you waive reading and advice or rights?
That's correct, Your Honor.
And do you wish to enter pleas?
We would enter a not guilty plea at this time.
All right, not guilty pleas will be entered to all the counts. Thank you. Then we just make sure that got taken care of. All right. So I just, with regard to the other things that you may have filed in support, I haven't received those, so you might double check. There might be a problem on your end, or it might be a problem that's lost in the system. But you filed it. It looks like the motion to change venue was filed on May 18th. So I can't. It's not like it's a last-minute filing that didn't make it into the system. Something's amiss, perhaps on your side of things. So purposely agent provocateurs. If you want to file supplemental, I'm happy to give you a chance to do that when we're done. But
absolutely, yes. I'd like the opportunity to file a supplemental paper. I did file a declaration, or at least I thought I did. As soon as we're done presenting the oral argument, Your Honor, I'm happy to ensure that my declaration is adequately filed and served on counsel.
Okay. I also did not receive any supporting documents or declaration or memorandum of law or anything of that nature.
Yeah, so I'll give the state a chance to file a response to any supplemental. Purposely agent provocateurs. But we can do at least a factual record now. I'll wind up taking the matter under advisement.
That sounds fine, Your Honor.
All right, so now you can go ahead and proceed with your argument. I apologize, Ms. Counter. I just wanted to be clear. I didn't see anything. Purposely agent provocateurs. I don't even know why this is necessary. Purposely agent provocateurs. I know nothing about the gentleman. Never seen him before. From the incident that I'm aware of. Purposely agent provocateurs.
That explains why I haven't received a response from Mr. Mintz in this case.
Purposely agent provocateurs.
Should we set the date out for a different date on the criminal motions docket, Your Honor, or should we proceed this morning as?
Purposely agent provocateurs. I'm happy to do that if you want to. If you prefer, if everyone would prefer, we could set it out a couple weeks or whatever time period you need to file. He needs a response. I'm happy to deal with that way. Do you have a trial date coming up?
We haven't set a trial date yet. We are scheduled for a 35-day call this afternoon.
Okay, so I mean, Mr. Mintz, what's your pleasure? Would you rather just do it later on?
Yeah, either way is fine, Your Honor. I think if
purposely agent provocateurs.
There's a witness and the witness is here now, if I'll defer to counsel if she wants to take the testimony now and then to save everyone's schedule. But so I have no preference though.
I'd feel better about it if my written motion were received by the court in advance of the proceeding. So I don't mind setting for a different criminal motions docket day. And my witness will be here at that time. I know where to find him.
Sorry, Mr. Moran. All right, so let's talk about when you want to do it. Today is the 15th. I know nothing about the gentleman. Never seen him before. They're purposely agent provocateurs. A week from now is perhaps not enough time to give the state a chance to review it and respond. Do you want to try for the 29th?
Yes, Your Honor. That works for the defense.
But to delete the no contact provision between two co-defendants alleged to have committed a person felony.
Mr. Mintz?
That works for me, Your Honor.
All right, June 29th, it is at 8:30 in the morning. I apologize, Mr. Collin, but sounds like there was some snafu in the electronic filing because her motion made it through, but the rest of it did not. So like I said, I know nothing about this case. I don't even know what the basis of why she wants it. So there's purposely agent provocateurs. It'd be helpful for everybody to read it in advance and know what's going on rather than winging it. All right, that's what we'll do. I'll see you, or maybe it won't be me, but someone will see you on the 29th of June.
Your Honor, I do have a request. Would Your Honor be willing and able to set the 35-day call out to the afternoon of the 29th as well? Just in light, I'd like to litigate this issue before we use up the court's time on a conference. If we're able to do that and just have the cases tracked so that it's on the same date of June 29th, that would be preferable for the defense.
Mr. Mintz, your position on that, and I'm going to have my staff check and see if that's even available.
That's fine with me, Your Honor.
Yes?
Yeah.
All right, so yes, well, I'm willing to do that. Will you submit an order for my signature this morning or taking it off the 35-day call today and setting it for the 29th at 2:30 in the afternoon?
Absolutely.
Right, so Mr. Collin, that's your next date before the court is the 29th of June. There's purposely agent provocateurs. You got two dates. One's this 8:30 hearing on your motion. The other's 2:30 that day. So like I said, I know nothing about this case.
That this case in particular did have quite a bit of attention online, and it was unique to them.
So like I said, I know nothing about this case. I don't even know what the basis of why she wants it. So there's purposely agent provocateurs.
Additionally, the cross-examination by Mr. Mintz revealed that Mr. Collin sends emails to the judges and attorneys involved in this case.
There's purposely agent provocateurs.
I think that goes to the argument that he'd be unable to receive impartiality in this area if that's what's happening.
So like I said, I know nothing about this case. I don't even know what the basis of why she wants it. So there's purposely agent provocateurs.
It is.
Well, why do you think that? What makes you think a judge reads the emails? I mean, I get emails all the time from people who I don't recognize. Our protocol is I'm not even allowed to open them. There's purposely agent provocateurs. If I don't recognize the sender's name, I'm not even allowed to open them per OJD policy. I never even look at those things. From the incident that I'm aware of from the PC affidavit. Purposely agent provocateurs. I just send them on to somebody else who screens them to make sure there's something I have to look at. Your presumption that merely because somebody puts something in an email box means that somebody reads it is just based on nothing. It's not how it works.
You called me an agent provocateur in our first hearing, Your Honor.
There's purposely agent provocateurs. That was a characterization of what the behavior you engaged in, but that's not my point. An
agent provocateur, Your Honor, is someone who goes out and encourages someone to break the law so they can be charged with the crime. That's not what I was doing at all, Your Honor.
There's purposely agent Go ahead, Ms. Counter.
Thank you, Mr. Cullen. In order to preserve Mr. Cullen's right as it relates to this trial, the defense would respectfully request an order granting a change of venue in this matter. Thank you.
So, like I said, I know nothing about this case. I don't even know what the basis of why she wants it. So, they're purposely agent provocateurs. All right, Mr. Mintz.
Thank you, Your Honor. I did not file a written response. That's correct. I may be citing just about 4 cases. And I'll discuss those, but it's nothing. All of those cases essentially stand for the point that voir dire is an important and safeguard that will ensure that a defendant gets a right to a fair trial, and that can be the case in this particular case. The state would submit that voir dire will fix all this, will provide a sufficient safeguard to ensure Mr. Cullen receives a fair and impartial jury at trial. Counsel can ask questions of the prospective jurors, determine if there's any preconceived notion or knowledge of the case, and those jurors can be dismissed from the case, and essentially the important voir dire process can serve its function in a situation like this. In State versus Sparks 336 OR 298, Oregon Supreme Court case. These are all murder cases, by the way, where the court found that even with evidence of newspapers and opinion poll done about rape murder case, that the jury selection process provided that sufficient safeguard, and that a jury can be instructed and will be instructed to listen to the evidence, only the evidence at trial, and that will be sufficient with the voir dire process as well. State versus Fanis 336 OR 63. There was a newspaper poll and report showing that 71% of voters thought the defendant was guilty. In that case, the record did not disclose a deep and bitter prejudice against the defendant. These are, it sounds like situations where there's maybe the potential for much more serious feelings towards the defendant. And again, the voir dire process can expose the impartial jurors and they can be eliminated. State versus Barone 329 Oregon 210 1999. Just because there's pretrial publicity doesn't mean that a change of venue happens automatically. Of course, the court can look at whether, what it says in the statute, whether it's satisfied that there exists in the county, whether or not there's so great a prejudice against the defendant that he cannot obtain a fair trial. And again, the voir dire process, customary in all cases, obviously, can secure that. That is really all I have to say, Your Honor, and I'd ask that the motion be denied.
Ms. Counter, anything further? Sorry, Ms. Counter, anything further?
No, Judge, thank you. Sorry, I was on mute.
That's all right, no worries. All right, so the amount of the mask mandate and people's reaction to it caused quite a bit of stir around the entire country. The states were divided, political parties were divided, families were divided. There were issues all over the United States about this, and people all over raised concerns about it. So that is not in any way unique to the Lane County or to this defendant. And there were strong feelings about it either way. The publicity that's referenced in this case is relatively minor, frankly. I've sat through cases where football players have been and Mr. Moran made reference to this, where UO football players have been charged with crimes, and you get a media circus around it. I've sat through cases capital murder cases with Mr. Moran where, they're live stream or putting up video plus daily coverage of her in a variety of papers around the state. So there's nothing about this case that in any way gets anywhere close to that level of publicity in this matter. The fact that a small percentage, this is a tiny percentage of the population who may be talking about this stuff on the internet. It's clearly less than 1%. Frankly, it's less than 1/3 of 1% of the population of Wayne County. As Mr. Mintz correctly points out, voir dire is a process by which parties find out whether or not someone has a preconceived notion about the facts of the case, not whether they feel that a crime is wrong or not. Things are crimes because as a society we say they're wrong, but do they have some preconceived notions about the facts of the case or the defendant in this case? So, and that's the process for teasing out those people. And will there be some? Probably. There'll probably be some people who've heard of this story, especially when you start talking about the facts of it. But to say that it's so, I don't find that the defendant has proven to me that the prejudice, if such great prejudice exists in Lane County such that he would not receive a fair trial. As Mr. Moran said, even on KEZI, there was a division about how the KEZI comments were divided about equally about people who thought mask mandates were wrong and people who thought they were right on. So there's no reason, no showing that it's so great a prejudice that it would be unfair, and therefore the motion is denied. All right, thank you all very much. Have a good day.
I'd like to say for the record really quick that oh, okay, well, he committed...
I'll give you a call, Ricky.
Sure. Perjury is totally cool on the record.